Okay, we left off talking about the nomination criteria, looking at the different characteristics that a president will look at when nominating someone to the courts or to the Supreme Court. Okay, maybe the biggest criteria for the president is going to be the chances of getting confirmed, right? Which is going to have a lot to do with whether or not the president has a majority of his party in the Senate, or whether or not it's a divided government and it's the opposite party. Okay, if it's the opposite party, right? So let's say President Trump is nominating someone and the Democrats control the Senate. Chances are the president's going to have to nominate someone that's a little bit more moderate, right? Not as heavily conservative, because he has to get the approval of a Democratic Senate. Okay, and that often happens, and it happened more often back when the Senate could filibuster judicial nominees. And now, since they've done away with that, we are probably getting more conservative judges because they only need a simple majority to get confirmed in the Senate. Okay. Make sure we're familiar with what senatorial courtesy is, right? Where the president asks for basically the recommendations of senators from that area, usually for the district courts. It's just kind of tradition. Exactly what it says, it's courtesy. It's not in the Constitution, but it's kind of been a common practice. President Trump hasn't necessarily used it a lot, but he also has not done a lot of things that have been traditional at times. Okay. All right, next. So the confirmation process, okay, actually getting confirmed, trying to focus it there a little better. Okay, so they will be investigated, right? I mean, the FBI is going to fully investigate them. That's why we had things that came up with, like, Judge Kavanaugh and, his charges of sexual assault and so forth. It's because that comes up in an investigation, right? They're going to investigate your personal life. They're going to investigate your professional background, okay? You're going to have lobbying that's going to be done by interest groups to try to convince senators, not to vote for somebody or to vote for somebody, right? If you're going to have a conservative justice put on the court, and let's say that they're pro-life, you're probably going to have, pro-choice groups really lobbying people in the Senate to not vote for this person, right? So that's kind of the process. Okay, where lobbying groups will try to use their influence, whether it's promise of helping on campaigns or whatever it might be, to prevent or to encourage certain people to get confirmed. Okay, then there's a Senate Judiciary Committee, and it's the committee that actually does, brings the judge before the committee, answers all these questions. We saw some of this with the Judge Kavanaugh stuff. There's actually a video in the folder that's really long, but you can just watch parts of it. They show you, it can be a really difficult time for these potential justices being really grilled by members of the Senate Judiciary Committee. And then the Senate Judiciary Committee makes a recommendation to confirm or not to confirm them, and then it goes to the full Senate for a vote. Okay? And like I said, today it does not take 60, because you can't filibuster judge nominations. It just takes a simple majority. Okay. There's the Senate Judiciary Committee. Scan up here a little bit. Okay. All right. So let's look at what cases the Supreme Court hears. Okay, and kind of what's the process of it. So first of all, there's a term you need to know. It's called a writ of certiorari. Okay. If the Supreme Court is going to hear a case, it will issue a writ, which is just, again, a legal document, which basically is saying we are calling this case up, okay, from the usually the Court of Appeals, okay, and it takes 4 justices. That's why we call it the Rule of 4. It takes 4 justices to say, hey, yes, we're going to issue the writ of certiorari, and we're going to call this case up to be heard. Sometimes you'll hear it just be called granting cert, C-E-R-T, so be familiar with that. So if the court issues a writ of certiorari, it's agreeing to hear the case, and it only takes 4 of the 9 judges to hear it, okay? The cases have to, involve some type of federal question or constitutional issue. And the courts only hear 75 to 80 cases a year, and they get a couple thousand, right? And so it's got to have a large constitutional issue. It's got to affect the entire country for the Supreme Court to decide it's going to hear the case. They have clerks that obviously have law degrees that kind of give a first pass through all the petitions for cert that they get. And then the clerks will make a recommendation. Hey, we think you should look at these as potential cases to hear, okay, as potential cases to issue a writ of certiorari for. Okay, so 4 judges in order to hear a case. All right, now, if the federal government wants a case to be heard, it'll be heard, okay? And the person that, and this person sometimes is referred to as the 10th Justice, as the Solicitor General, okay? And the Solicitor General is responsible for all cases brought before the Supreme Court from the federal government, okay? So that's really important. If the federal government wants something to be reviewed, right, they're going to get it reviewed. Solicitor General goes to the court and says, we need you to hear this case. It's going to be heard, okay? So it's not the Attorney General, it's the Solicitor General. Don't get it confused, okay? The Solicitor General is the one that's going to argue and present the case to the court from the federal government, okay? All right, if there's a conflict among the courts of appeal, so let's say you have a decision made about the Pledge of Allegiance in one court of appeal that says, no, you can't say the Pledge of Allegiance is unconstitutional in the schools. But you have another court of appeal that says, no, saying the Pledge of Allegiance in the schools is not unconstitutional. That's a conflict among the different courts of appeals or the different circuits. Remember, it's the same term, circuit, court of appeal, same thing. So those decisions only affect those circuits. So now you have contradictory decisions. The Supreme Court will hear that case in order to decide what the final decision is, okay? All right. The other very important term here is what we call an amicus curiae brief. Make sure you understand this, okay? This means, amicus curiae means friend of the court. So a brief is simply a written legal argument. So each side that presents their case to the court is going to submit briefs. This is what we believe the issues are. This is what we believe the decision should be based off of, so on and so forth. However, there are other groups besides the 2 parties involved that will be affected by the court's decision. They will also file separate briefs, okay, to give the court their legal opinion on this case. So if there's a case, let's say it's Ohio versus the United States, and the case is about abortion, you're going to have every pro-life and pro-choice group submitting amicus curiae briefs before the Supreme Court on how they think the court should rule. Even though they're not directly involved in the case, they are definitely affected by its decision, and so they file this amicus curiae briefs in order to get their opinion before the court. So this would be an example of an interest group trying to affect the judicial branch. Okay, remember that. So please be familiar with these here. Okay, if the federal government is a party, the case involves a conflict among courts of appeals, it presents a civil rights or civil liberties issue, there's an ideological policy preference of the justices, or has significant social and political interest, okay, the courts, these are the cases that the courts will tend to hear, okay? Remember, and this is all going to be appellate jurisdiction. This is not original jurisdiction. This is hearing cases on appeal. All right, so here's how it works. Then each side is going to get 30 minutes to argue their case. Okay, they're going to stand up before the court, and the courts are going to ask, the judges are going to ask them questions, and they have a total of 30 minutes for each side. Okay, these are not nearly as important as the briefs. Oftentimes the judges, maybe they want something clarified, or they think of something on the spot, but oftentimes judges pretty much already know based off of the briefs how they're going to make their decision. Okay, so after they hear the oral arguments, the judges will meet in conference, which is only them, no law clerks, nobody else, just the 9 of them, and they discuss it, they argue over it, and then they vote. Okay? They vote on what the decision of the court is going to be and what side is going to win. And there are different types of opinions. The first type of opinion is not on here on the slide. It's called the majority opinion. Okay? And it's usually going to be written by the most senior member of the majority, right? So it's going to take 5 judges minimum to have a majority. And they're going to write this opinion of why they ruled the way they did, what's the constitutional issue, and they can be very lengthy. Okay, I have a book in my room that is just full of majority opinions. Okay, this is what the issue was, this is what the standard is going to be, this is why we voted this way. Okay, a concurring opinion is sometimes written, which means, let's say you have 5 judges, vote one way, so they're the majority, and 4 of them agree why they voted that way, but the other one does not agree on the reasoning. They have a different reason why they voted with the majority, so they're going to write a separate opinion based on why they voted that way. So it's like if 5 of your friends are going to take a vote to go to Polaris, right? And 3 say, yes, let's go to Polaris. That's the majority, okay? But all 3 of those people that voted to go to Polaris have 3 different reasons of why they want to go to Polaris, right? One wants to go for the restaurants, one wants to go see a movie, one wants to go to just the mall, okay? So they all agree to go to Polaris, but they have different concurring opinions of why to go there. That's what an concurring opinion is. All right, then you have a dissenting opinion, which is going to be obviously the side that does not win, and why they voted against the majority. These are often not important initially, but down the road they can be, because sometimes when the court changes its mind, right, the dissenting opinion 10, 20, 30 years later might become the majority opinion, and they'll use this for some of their reasoning. Okay. All right. So judicial philosophy. This is very stereotypical, but we have judicial restraint and judicial activism. Judicial restraint is often considered to be the conservative approach to judges making decisions, and judicial activism is often considered the liberal approach. Often what it is if you're showing judicial restraint, it's the idea that you believe the court should only make a ruling when it has to. It's not the court's job to set policy and to tell the Congress and to tell the president and tell the states what they're supposed to do. They're ultimately just going to rule things constitutional or unconstitutional, okay? Where judicial activism is much more of a policy-driven approach, right? Like Miranda versus Arizona is judicial activism. They're literally going to tell law enforcement that you have to read people their rights if you're going to arrest them, and they have to understand them. This is a difficult concept to understand, and I don't want you to use this as an example, but it's almost like judicial restraint is an NFL referee that is simply going to decide if a rule is broken in a game, as opposed to judicial activism where the NFL referee is going to actively make their own decision on what that rule is supposed to be and interpret it their own way and then say, this is what the rule is now going to be, okay? It's often said, if you agree with the ruling that the court makes, they're showing judicial restraint. If you disagree with the ruling, they're showing judicial activism, right? A lot of people would consider Brown versus the Board of Education to be judicial activism. Other people would say, no, it's not judicial activism. They're just simply interpreting the 14th Amendment differently than they did with Plessy versus Ferguson, okay? Strict constructionism simply means the idea of trying to strictly interpret the Constitution, okay? What did it originally mean? How does that apply today? You don't believe that the Constitution really changes over time. I don't know that this is really a legitimate thing, right? But it's almost like people in the court that ruled in Roe versus Wade and they ruled against abortion are going to say, there's nothing in the Constitution that says you have a right to privacy, right? There isn't, okay? But when you put some of the amendments together, the other judges would say, well, it's kind of apparent that there is a right to privacy. So one is kind of strictly interpreting it, the Constitution, the other one is not strictly interpreting it, okay? All right. Now, even though the judges aren't elected, they are still affected by public opinion. the court can enforce its own rulings, right? It has to rely on Congress, it has to rely on the states, it has to rely on the president. And it needs the confidence of the public to believe that the rulings that it's making are legitimate. And if the public loses confidence in the court, their rulings really aren't going to hold any weight. And you might not get a state upholding a Supreme Court decision. Okay? So this often leads to the fact that the court's not going to change its mind very often. Okay? They're going to rely on that stare decisis, right? Let the decision stand. Okay? Because if they're changing their mind every 2 or 3 or 4 years, it can be very difficult to comprehend what the law is, what the constitutional issue is. Okay? And so they very much still need the support of public opinion to basically back up their decision, so people that will follow it, even if they don't necessarily agree with it. Okay? Right, here are some important cases here. The ones I think that we have to know, right, are McDonald's Chicago and Citizens United versus the FEC. Okay? But you look over here, it's just trying to give you an idea of popular support for it, okay? Whether it was opposed or not opposed, okay, before the decision. All right. Again, so the only way for the court's decisions to change is that it can overrule itself. Okay? You can make a constitutional amendment, or the issue or law or whatever can be modified to kind of fit with what the court says, right? If part of a law is constitutional but the other part is unconstitutional, the court can, the Congress or whoever it is, maybe it's a state legislature, can adjust that law. Okay? Some of the newer issues that the courts have been looking at have been stuff like voting rights. The death penalty has come up. Obviously, things related to immigration have come up. So that's changed over time. What's judicial review? The right to review acts of government and whether or not they are constitutional or not. And what's the Supreme Court case where the court said we have this power? Remember, this isn't strictly in the Constitution. The courts kind of gave themselves this power. Right? I talked about this, right? Implementing it. All right. That's it, guys. We're going to review in class on Tuesday so I can answer any questions. Terminology like stare decisis or writs of certiorari or amicus curiae brief, those are all going to be on the test. All right?